The consent of other side, I beg, item number 27, Lord.
20?
27, Lord. In this matter, Lord, we will find the Bakalakama, we need to have some time to file the affidavit.
27.
27.
Yes, sir.
You have taken consent.
Yes.
Yes, sir.
You are for the
Respondent
respondent,
number 4.
Mr. M.K. Bora. Mr. M.K. Bora, Learned Counsel, appearing for respondent number 4, with consent from the other side, seeks 2 weeks time to file return in the matter. Prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry.
No, sir. I beg to mention item number 41, Lord. Respondent will comply, Lord. They will
Complied.
Yes,
Item 41.
41, Lord.
You are for the petitioner. Petitioner.
Yes.
Your name?
J1.
Heard Mr. J.U. Ahmed, Learned Counsel for the contemner. For the petitioner. Stop. Mr. So-and-so, Learned Counsel for the petitioner, submits that during the pendency of the contempt petition, the judgment and order against which the contempt petition has been filed has been duly complied with. In view of the aforesaid endorsement, nothing survives for adjudication in this contempt petition. Accordingly, the contempt petition stands closed.
Yeah, please, Your Lord. I beg to mention item number 11, Lord. Mr. JMS Chaudhary is ill, Lord. It may be adjourned for the day.
Item 11. Yes, Mr. Hawk, what do you want?
Mr. JMS Chaudhary, arguing counsel, Lord, he is not well today, Lord.
He's not well.
Not well.
Have you informed the other side?
Yes, Lord, he is informed, Lord.
Mr. AVT Hawk, Learned Counsel for the petitioner, seeks adjournment submits that the arguing counsel, Mr. J.M.A. Chaudhary, is indisposed today and seeks a short accommodation in the matter. Prayer is not opposed. Released after 2 weeks on a date to be fixed by the registry.
Obliged.
50?
50-53. In this matter, Lordship, guide petition appear expect a special counsel, KTPFO.
52 and 53?
Yes, order matter.
Order.
Not by me.
Right.
52 and 53 before any other bench.
Obliged.
Yes.
May it please, your Lordship. Lordship, with the consent of the petitioner, I pray for an adjournment in item number 17.
17.
17. I am for respondent number 9, 10, and 11. Lord, the matter may be.
You are for the respondent.
I am for the respondent.
But I think affidavit in reply was required to be filed
Yes,
with the petitioner. What happened?
My Lord, I need to file my affidavit in opposition, my Lord.
All right. Have you informed the petitioner?
Yes, yes, petitioner I have been informed.
Your name?
M. Dotto, my Lord.
Mr. M. Datta, Learned Counsel, appearing for respondent number 9, 10, and 11, seeks 2 weeks time to file return in the matter. Prayer is not opposed. Relist after 2 weeks on a date to be fixed by the registry.
Obliged.
Yes.
I beg to mention item number 14, Lordship.
1-4.
1-4.
Yes.
Lordship, kindly adjourn the matter for 1 week.
Why?
I have some personal request.
You are for?
I am for the petition.
Affidavit in opposition has been filed.
Yes.
You are not going to file reply?
I'll reply, resender, I will reply.
You file or not?
I have not already.
Then you say that because today you are taking time, next day you will come and say, I need 2 weeks time to file rejoinder. Your name?
I'm for the
Mr. D. Chutia, Learned Counsel, appearing for the petitioner, seeks 2 weeks time to file rejoinder against the affidavit in opposition filed by
respondent number 2 and 3.
2 and 3. Prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry.
It may be fixed. I'm for the respondent.
Next. Registry will give you the date.
May I please? Item number 34, my lord. I, on behalf of Mr. A.R. Talukdar, my lord, he is on medical leave today, my lord. And I have
Medical?
taken the consent out from the other side, my lord.
30?
Item 34, 34, my lord. I am A.S. Tapadar, my lord.
34.
Yes, my lord.
All right. You are for the?
A.R. Talukdar, my lord, who is on record,
Uh,
my lord.
No, your name.
A.S. Tapadar, my lord.
As Mr. A.S. Tapadar, Learned Counsel, seeks Learned Counsel on behalf of Mr. A.R. Talukdar,
Yeah, my lord.
seeks posting of this matter after
1 week, my lord.
1 week on the ground that Mr. A.R. Talukdar is indisposed. prayer is not opposed, relist after 2 weeks on a date to be picked by the registry. Yes,
I'm
next.
obliged. I'm obliged.
May I please, your lordship? Lordship, I beg to mention item number 60.
1660.
60.
Yes, what do you want in 60?
Next week.
Hmm?
Next week.
Sorry?
Next week.
Next date.
Next week.
No, but why? Why do you want an adjournment?
Sorry, MS P. P. Gohai is out of station.
I cannot hear you.
P. Borgohai is out of station.
B. Borgohai.
P.
P.
Gohai. P. Gohai.
P. Gohai. But there are so many councils. Mr. B. Buragohai, MSD Borgohai, Mr. UJ Saikia, then is Mr. P. Gohai. Where are the other councils? Your name is there,
Yes. No.
not there.
No.
What is your name?
M. Bora.
MSM Bora Learned Council, your name is there. Why are you saying no? MSM Bora Learned Council appearing for the, and have you informed the other side?
Yes, lordship.
You are there. MSM Bora Learned Council appearing for the petitioner seeks posting of the writ petition after 1 week
Yes.
on the ground that Mr. P. Gohai, who is arguing, the arguing counsel is out of town. Prayer is not opposed, relist after 2 weeks on a date to be fixed by the registry. Yes,
Text mention item number
36,
26.
26. Yes, what do you want in 26?
The respondent has filed an affidavit of opposition. However, we will need 2 weeks time to file.
All right. Your name?
L,
MSL.
L is
So and so learned counsel appearing for the petitioner seeks 2 weeks time for filing rejoinder against the affidavit in opposition filed by respondent number.
we are for the plan to,
Sorry,
we are for the plan.
no, affidavit in opposition filed by respondent number
Respondent number
1.
1.
Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry. Yes. Mentions are over? Yes.
And item number 4, my lord, that is that is standing before the Supreme Apex Court, my lord. So that was last listed on 4/2020.
Item 4.
Item 4, yes.
You are there in 4.
Yes.
So the matter is pending before the apex court.
Yes, ma'am.
When was it last filed? Last
It was
listed
last 4/2025.
in item 4. MSA Gayan, learned counsel for the respondent, submits that the issue involved in this writ petition is sub judice before the apex court. Do you have the number?
Yes, ma'am. In SLP.
In SLP number 2084
8
20848
20848 of 2024.
of 2024. Stop. Then I'll sign a die, adjourn it. Adjourn, sign a die. Parties are at liberty to apprise the registry as and when there is development in the matter for listing the matter. All right? And you record the present. Your name?
P.R. Sakma on
Hmm?
behalf of PK Das.
Your name? PK, you are
P.R. Sakma
so and so on behalf of
on behalf
PK Das,
PK Das. Yes,
petitioner or MSA Gayan. All right.
I know.
Yes, call the list.
Item number 1.
May it please your lordship, matter relates to compensation relating to Virat property lordship. Petitioner land was secured lordship.
Yes, direct compensation.
Yes, lord.
Yes, what happened? Instructions.
The authority prepared the list.
Yes,
lordship.
who is supposed to be? Yes, Mr. G. Goswami, Standing Counsel, NF Railway. For the R4, seek further 3 weeks time to obtain instruction. Yes, Mr. Goswami.
One thing, my lord, can it be taken up tomorrow, my lord? I have got a my lord, wrong file, my lord. That is why, my lord, my
All right.
extremely sorry, my lord.
No
Tomorrow, my lord,
problem. You're Goswami, right?
Madam.
Mr. G. Goswami, Learned Standing Council, NF Railway, submits that inadvertently he has brought the wrong brief and accordingly seeks an accommodation for the day. Prayer is allowed. Relist Friday. Vacation of land.
Lordship, in this case, the case was last listed on 27/9/2019, Lordship. So I need some time to obtain some instruction, Lordship, because I could not communicate it with my client, Lordship. And they have not filed their affidavit in opposition.
What happened? No notice. There is no noting.
Step has been taken, Lordship. Step has been taken.
Steps not taken, na?
Lordship, taken, Lordship.
Taken.
Taken, Lordship.
No, but,
On 39/2019, Lord.
all government advocates.
Yes, Lordship. Because there is no private respondent, Lordship. Government is the.
So you want to obtain instruction,
Yes, Lordship.
Mr. Kalita?
In the meantime, let them file their opposition, Lordship. Affidavit.
Yes, what about the instructions? Affidavits, returns,
We have not received.
but it's a 19 matter, Mr. Talukdar.
I know.
So
I'll,
any plan to file something?
I'll communicate again.
Hmm?
I'll instruct.
The
them.
case is that, Lordship, I have a Medipatta land. I have taken the 10 land on lease, Lordship. They have given a notice to vacate my land. That is the case.
You
Let me
get
reply.
the instructions. What is happening? What is the status? Next week.
Right.
Next week I'm posting it.
With the mortgage, it should be 2 weeks at least.
But you take instruction.
Right.
Heard Mr. D. Kalita,
Yes, sir.
Learned Counsel for the petitioner. Also heard Mr. B.K. Talukdar, Learned Senior Counsel, stroke Additional Senior Government Advocate, assisted by Mr. P.K. Medina. P.K. Medi. Anybody else? Mr. A. Bhattacharya, Learned Standing Council Revenue. Mr. Talukdar will quit, seeks 2 weeks time to obtain instruction in the matter. Prayer is allowed. Date
In the meantime, interim order may be continued.
relist on such and such date. Rupak, give a date after 2 weeks. Interim, if any, shall continue till the next date of listing. You
Okay.
also obtain your instruction.
Lordship, Lord.
May it please your lordship, we are no longer engaged in this case. As per communication dated 5/2/2025, the entire case record has been handed over to the petitioner along with NOC.
This is the second withdrawal of counsel in the same case. Earlier, there was a first set of counsel, they stopped appearing. The interim order was vacated, there is an order.
Interim is vacated.
Interim is vacated. Now they have filed an IA, for reinstating the interim order.
But yet there is a change.
There is a change in counsel.
Let them do whatever they want to do. You know, there is no stay,
Yes.
isn't it? Your name?
S. Dasgupta.
Miss S.
Dasgupta.
Dat Gupta.
Yes.
Have you filed any affidavit saying that your file have been returned and all that?
No, we have intimated the same thing to the registered judicial on 1/5/2020
Intimation by what?
by enclosing the letter sent to the petitioner.
That will not do. You file an affidavit. MS
S. Dasgupta.
Das Gupta, Learned Counsel appearing for the petitioner, submits that they have, her office has returned the brief to the petitioner and that they are no longer in the case representing the petitioner. However, no affidavit to the same has been filed till date, nor there is any new counsels have been engaged on behalf of the petitioner. So she accordingly seeks 1 week time to file the necessary affidavit in this regard. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry. Mr. A. Ganguly, Learned Counsel appearing for the
Respondent number 3.
respondent number 3 is present.
Lord, the petitioner was, my lord, dispossessed by the, he said that actually, but what had happened, the petitioner.
Pleadings are complete, Mr. Das?
Yes, my lord, pleadings are complete, my lord.
I don't see any reply from your end. It's only the affidavit in opposition.
Yes, because the issue is, my lord, we were dispossessed.
Huh?
Now, we were dispossessed from a plot of land, my lord. Now, the GMC says that it was, the police says that it was on the basis of some requisition by the GMC. So, and now the GMC has filed an affidavit. GMC says that they were not aware of it.
May please, your lordship, the petitioner's main grievance is against respondent number 2. Lordship, I am for the respondent number 6, the private respondent, lordship. Lordship, let the respondent number 2 file their reply.
Who's R2? Who is R2?
They have filed, my lord. They have already filed, my lord.
R2 affidavit is not here. R4 and R3.
GMC is the already has filed, my lord. GMC has filed, my lord.
R2 is GMC.
GMC. I'm to
Huh?
R2 and R3 C.
You have not. Mr. Naik, give him a copy.
Yes. In view of the, my lord, pleadings of the GMC, my lord, they said it is the police of and the private respondent.
Let,
Yes.
you are for the private respondent.
Private respondent.
Let him have a copy.
Yes. Let him file.
Mr. Your name?
Dr. PP Mehdi, lordship.
Huh,
P. Mehdi.
Doctor. Dr. PP Medhi, Learned Counsel appearing for the respondent number
6.
submit that a copy of the affidavit in opposition filed on behalf of respondent number 2 stroke GMC has not been furnished to him. Let Mr. P. Nayak, learned, you're appearing as a standing counsel. Learned standing counsel, GMC, assures that a copy of the same shall be furnished to so and so within the course of the day. Relist after, give a date. This is 23 matter.
22, madam.
Relist after 1 week on a date to be fixed by the registry.
Oblige.
Is there any interim prayer, Mr. Das?
No.
Any interim was there?
No, madam.
Okay.
May it please, your lord.
Stop construction. Yes, affidavit in opposition has been filed. What about rejoinder?
No, we don't want to file any reply, but lordship, respondent number 4 is yet to file their.
Who is R4?
Insurance company.
Who is appearing for R4?
On H4, Buragoy has filed, color number has shown in the system, lords.
Who has filed?
H Buragoy. In the system, it is shown like that, lord.
Because the name is not reflected.
Not reflected, lord.
H. Buragoy is reflected, lordship. H. Buragoy and BJ Mukherjee, lordship.
This is item number?
6, lords.
And lordship, our name is also showing as respondent number 1 to 4, lordship. We are representing 1 to 3, lordship.
Anyway, that is all right, but your name is there. Yes, H. Buragoy is there. They have not filed affidavit.
Lordship.
We don't know. We
No,
don't
my
even know who they are. Ever appeared, lordship.
What is to be done then?
Lordship, my submission is that this matter is not maintainable, lordship, because this primary grievance is against a private entity, lordship. It's not a state.
What is his grievance?
Lordship, his insurance premium has not been paid. Or,
Is it?
yes, your lordship. His grievance is that he has taken a loan, lordship.
This is a private company, the insurance company.
Yes, your lordship. Respondent number 4 is the life insurance, lordship.
SBI, State Bank.
Lordship, SBI life insurance, lordship. Respondent number 4.
No, but it is a state company, it's a corporation then.
No, your lordship, it's not related with SBI, lordship. It is a private entity, lordship.
SBI life insurance is not related with, what does the S stands for?
Lordship, it's State Bank of India. But
Then?
Lordship, but it is.
What are you saying, Mr. Counsel?
Yes, your lordship.
In your writ petition, how have you,
Lordship.
where have you stated the SBI life insurance is a corporation under the state? Where are those averments, Article 12 averments?
But my lord, we are mainly filing against the State Bank of India, lordship.
Where are those averments?
Lordship.
You have taken this issue of maintainability in your objection.
Yes, hello.
Have you, then you reply,
Lordship, I
why
will
are
file,
you filing reply?
I will file reply. Lord.
Huh?
Lordship, Lordship,
He's raised a issue of maintainability.
Lordship,
You file your reply
Lordship, I will file, Lordship,
because you have not said anything in your written petition also.
Lordship.
How can the court decide then?
I'm sorry, Lordship, I will file, Lordship.
Your name,
R. Fukon, Lord.
Mr. R.
Fukon.
Fukan Laird counsel for the petitioner seeks 2 weeks' time to file rejoinder to the affidavit in opposition file on behalf of respondent number
1, 2, 3, Lord.
1, 2, and 3. Prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry. It appears that Mr. H. Buragohai, learned counsel appearing for the respondent number 4 is not present on call despite the name being reflected in the cause list. Let registry intimate Mr. So-and-so, learned counsel appearing for the respondent number 4 via WhatsApp, the next date of listing. The date did you
On 18 June.
15.
18.
8.1. Obliged.
Yes.
Item number 7, 8, 9, and 10.
Yes, Mr. Goswami. Affidavit in opposition.
Yes, my lord. This case, lordship, Mr. Dinath is appearing, lordship. He has some difficulties, lordship.
Huh?
He has some difficulties to their lordship. Okay, you know,
But what about the affidavit? Are you going to file? You're not
Yes.
going to file?
in item 7, everybody is there, lordship.
It's fine.
Yes.
Affidavit in opposition filed by R4 and 5.
Yes.
You are R4 and 5. Lanka Municipal Board.
Yes, lord.
Okay.
Replacement.
Hmm?
Replacement.
Mr. Goswami, Mr. N. Goswami, learned Junior Government Council. You're appearing as a Junior Government Council here. Are you appearing as a Junior Government Council? Junior Government Council submits that Mr. D. Nath, learned Senior Government Council, who is handling the who's the arguing counsel, has some personal difficulty today and seeks a short accommodation on that. Accordingly, seeks a short accommodation. Prayer is not opposed. Relist after a week on a date to be fixed by the registry.
My lord, that may be kindly fixed, my lord.
Why?
My lord, this is the.
Today also it has come. Anyway, give a date.
On 9th June.
Yes.
9.
Obliged.
Item number 12.
Lordship, we have our affidavit is ready. We have sent it for vetting, lordship. Can it be on the next week?
All right. Mr.
R. Fukon, Lord.
You are Mr.
SR Bolwa,
S.R. Borwa, learned Government Council.
Junior Government.
Learned Government Council submits that the affidavit in opposition on behalf of the state respondent,
Yes, lordship.
it-
Number 4.
respondent number 4, is ready and has been sent for vetting
Got
and accordingly seeks a short accommodation in order to file the same. Prayer is not opposed. Relist after 1 week.
1 week. Lord. Can it be on 6?
Mr. Chaudhary, anything?
Madam, there for the Indian Corporation, there is a stay on
So 1 week? 1 week, huh?
6.
And on top, you give the appearance, your name,
R. Fukon, Lord.
R. Fukan petitioner, the Moragot, M.K. Chaudhary, senior counsel, assisted by Mr. P. Sharma, na? M. Sharma, learned counsel appearing for respondent number 123.
Obliged.
Item 13.
May I please, your lordship? Lordship, may kindly produce order dated 6/5/24.
Yes. Enable municipal board to file necessary affidavit in opposition.
Yes, lordship.
Further time will be granted.
Huh?
Further some time.
Why? Why?
We have already informed them, but the reply is.
MS S. Musahari, learned counsel appearing for the municipal board. Submits that the instructions are still awaiting and accordingly seeks seeks listing of the matter after 2 weeks to enable in order to file the affidavit in order to file return in the matter. Prayer is not opposed, released after 2 weeks on a date to be fixed by the registry.
Lordship, a date may be fixed because already 1 year has passed, Lordship, because the last order.
All
is
right,
expired.
let them first file. Yes.
Item 15 and 16.
May it please your lordship. Lordship, I'm appearing on behalf of Mr. K. Talukdar. Your lordship, he is indisposed today. I'm praying for a short accommodation in the matter.
What is happening today? A lot of councils are being indisposed. Mr. Borpujari?
Yeah, my lord, in this matter, my lord, in these two items, 15, 16, we have extreme urgency.
Item
Item 15 and 16, which lordship is just now taking up, my lord.
15 and
But
16.
on behalf of the state, we have extreme urgency because of the fact.
When can Mr. Talukdar be in court?
Monday, your lordship.
Monday.
Monday.
Because my
Today is Wednesday.
Wednesday.
Why not Friday?
is Friday.
If not Monday, then Friday is also.
Huh?
Friday is also fine, your lordship.
Friday. They have extreme urgency.
Yes.
Readings are also complete. Lordship can call my lord immediately. Lordship can call on the basis of the materials and
We'll
records.
see on that
This is
day.
a small issue, my lord.
We'll see on that
My
day.
lord.
MS?
See Das, your lordship.
Sidas,
See Das.
learned counsel appearing on behalf of the petitioner submits that, but Mr. Talukdar is who? He's a briefing counsel?
He's a, yes, your lordship.
Briefing counsel or arguing counsel?
He's a briefing counsel, your lordship.
The
Mr.
briefing
Didas.
counsel, Mr. K. Talukdar, is indisposed, for which Mr. Didas, the senior counsel, is unable to, has difficulty in doing the matter today and accordingly seeks a short accommodation. Mr. Arbor Pujari, learned standing counsel, revenue, submits that there is extreme urgency on behalf of the state respondents. However, since mention has been made on due to medical grounds, he fairly submits that the matter may be adjourned for a day. May be allowed to be adjourned for a day. Relist on Friday, such and such.
Must have let you.
And so,
Item number 18.
ना ठीक है asking now. Ninety की petitioner open. Is that? Can we recall again or what? What is this? You have received, then you file. Sorry, item 18, huh? 18, right?
18.
None appears for the petitioner on call. MSU Das, learned additional senior government advocate, submit that instructions have been received and accordingly seeks 2 weeks time to place the same by way of an affidavit. Prayer is allowed, released after 2 weeks on a date to be fixed by the registry. Yes, land acquisition compensation. Mr. Roy, you have filed, yes.
My lord, my senior is coming for, my senior is coming. For a time being, it may be.
But are you going to file an affidavit or what?
করা যাবো?
Huh?
Yes.
They will file rejoinder.
Are you filing rejoinder?
Yeah.
Mr. Your name?
Abdul Wadud, A Wadud,
Mr. A?
Wadud, WADUD.
Mr. So-and-so, learned counsel appearing for the petitioner seeks 2 weeks time to file rejoinder against the affidavit in opposition filed on behalf of the state respondents.
Yes, sir.
Prayer is allowed to relist after 2 weeks on a date to be fixed by the registry.
Item 20.
PTC. What of your instructions are there? Can you file your affidavit?
Simple instruction, there is pending civil suit, that's why this time cannot vote.
Then let's wait for some time. Let's see if someone comes.
21.
Right.
Here, affidavit
This-
is filed.
My lord, in this case, affidavit already filed, my lord, kindly come to page 54. Regarding
Land demarcation.
partition and demarcation, my lord. In this case, what had happened, my lord, the order
But
for,
demarcation, is there not some Huh?
yes,
notification?
notified service,
Huh?
because under notified service, we have applied, my lord.
We have applied.
Thereafter, appeal also filed. After appeal, my lord, another online RTPS also filed. Then, my lord, page 54. 54, my lord, order already passed by the circle officer, my lord, for partition. But field partition and record partition not yet done. This is the grievance, my lord. And affidavit filed by the
54.
54, my lord.
What has happened in 54?
This is a partial partition, so the
Partial partition.
yes, so the DAC number and patta number will be changed. But the affidavit filed by the circle officer, my lord,
After this, what is to be done?
the record partition as well as field partition is required to be done.
What partition?
Record,
Record.
one record correction, my lord.
Record and field.
Field,
Field.
yes, my lord. But the affidavit filed by the circle officer stating, my lord, no consent was given by the co-pattadar, my lord. But as per section 97B, my lord, co-pattadar consent not required.
Where is that affidavit paragraph?
Paragraph 6. Page number 59.
Paragraph?
21.
Paragraph
Paragraph 6. There was plus in the middle portion, Lordship.
page 61.
59. Yes, paragraph 6.
Uh,
Yes,
exact
Mr. Roy.
paragraph 8 is
1 second.
Paragraph
6.
Lordship, the 6 is from Lordship, last few lines above, but the land measure.
Yes.
In the above mentioned, Dag and Patta has been recorded in the name of so and so, so and so, so and so. And so and so, which is the part of old Dag number so and so, therefore, considering the whole site of this. In the second class of land revenue regulation, as well as on the basis of last report, mutation was granted in favor of so and so, so and so, so and so, along with the existing pattadar by right of purchase and possession by register sale deed number so and so. Then Lordship, next paragraph 8, Lordship. As per record, Lordship. Paragraph 8, as per records available in this office, it is mentioned that the plot of land measuring so and so, under so and so, recorded in the names of so and so and so and so. Then Lordship, next page. Accordingly, a date for partition as well as demarcation of the above mentioned plot of land was fixed deponent by case number so and so. But the said partition as well as the demarcation was not done due to non-submission to the consent of the co-pattadars and inability to identify the part of land due to non-existence of any notional field boundary or lease. Later, the date was refixed or so and so by the office of the deponent for demarcation, but the petitioner verbally requested to concern dealing a system only for a partition, hence the date of demarcation has been postponed.
But regarding consent, my lord, in this case, my lord, consent from co-pattadar not required. Because, my lord, in DAC number 442, there is a land measuring 8 biga 1 kata, my lord. And we are, my lord,
So now what is to be done according to you, Mr. Roy?
Lordship, no consent was given co-pattadars.
No, you said due to non-submission of consent.
Yes.
Now, if they are not, they have given, they have not given consent or they have,
Not given. Because there was no boundary, how can we demarcate the land, Lordship, until and unless how much share? Let him file reply to that.
No, we have filed already, reply. We have filed.
No, but you see, I haven't, I'm not gone into the legality of the matter.
Yes.
But what I'm trying to understand is how to help the petition,
Yes.
right? Now, it appears that they are not saying that they will not do it.
Yes.
They are saying they're not being able to do it because the co-pattadar has not given the consent,
Yes.
for which they had fixed another date.
Right.
That was on 30/8/2024.
Yeah.
But on that date, the petitioner verbally requested to the concerned delaying assistant only for partition. Hence, the date of demarcation had been postponed.
Yes. But
Now, I have not understood this part.
my
It
lord,
has been postponed, not rejected.
Correct, it has been postponed.
yes,
So now next date is when? What has happened?
not yet.
Why don't you have the up-to-date instruction?
Look.
What has happened after this date?
And
Because you have not rejected it.
Yes, sir.
Now, if you are doing something and there is some hurdle, this court can give necessary directions. But
Look.
first, let us understand what is the up-to-date status.
Look.
Let them get the up-to-date status information.
my lord,
Lordship,
regarding consent, my lord. My
That
lord,
is the legal issue. We'll see that later because they are not rejecting it.
because, my lord, on that ground,
All right,
they are
Mr.
delaying the matter, my lord.
Let them have that instruction. Mr. S. Roy, na?
SS.
S.S. Roy, learned Government Council. No, don't say that. Heard Mr. So-and-so, learned counsel for the petitioner, as well as Mr. S.S. Roy, learned Government Council for the state respondent, and M.S. N. Bordoloi, learned standing counsel revenue. Stop. The issue relates to non-conclusion of the record partition and fill partition.
Yes.
It appears from the affidavit in opposition filed by the respondent number 4 that the record partition as well as the demarcation was not done due to non-submission of consent of the co-pattadar and inability to identify the part of land due to non-existence of any notional field boundary. And accordingly, a date was refixed on 30/8/2024 for demarcation. However, on that date, the petitioner verbally requested the concerned delaying assistant only for partition. Hence, the date of demarcation had been postponed. The affidavit does not indicate the up-to-date status of the subject partition stroke demarcation. Let the up-to-date status be furnished on the next date of listing. Mr. So-and-so, learned counsel of the petitioner, submits that in terms of section
97
97B of the
Assam Land and Revenue Regulation
Assam Land Revenue
and
and
Regulation
Regulation
1886.
1886, no consent from co-pattadar is required.
Yes.
Be that as it may, let the up-to-date, don't say anything. Relist after 2 weeks
My lord,
on a date to be fixed by the registrar.
my lord, date may be fixed, my lord.
Yes, next.
Your lordship, I pray for some more time, lordship, we are awaiting instruction.
Eviction.
Yes, without serving any notice, my house was demolished.
Demolished.
Yes, Lordship, nothing is.
Yes, Mr. Roy, I think the matter needs a serious,
2 weeks time. 2 weeks time.
Somebody's house has been demolished without notice. The allegations are very serious.
Yes.
Lordship, 2 weeks.
Notice was issued in December
9/12.
2024.
Yes.
We are now in May. We are in fact in the end of May.
2 weeks, lordship.
1 week.
Lordship.
1 week.
Lordship.
Allegations are very serious.
Lordship.
Mr. S.S. Roy, Leonard's junior counsel appearing for the state respondent seeks 2 weeks time to file affidavit in opposition in the matter. MS
J-Fall.
huh?
J-Fall.
J or Ali?
J. Paul.
J. Paul, sorry. J. Paul, learned counsel for the petitioner, submits that the issue involved in this writ petition is as regards demolishing the house of the petitioner without furnishing any notice and consequent and subsequent eviction thereof. Stop, huh? In view of the seriousness of the issue, 1 week time is given as by way of a last opportunity to the state respondents to file their affidavit in opposition in the matter, failing which, the matter shall be proceeded in accordance with law, and if need be, personal appearance of the officers shall also be issued. Ensure that the instructions are there.
Lordship is fixed it on.
Yes, after, 1 week, give a date after 1 week.
On 9th June.
9.
23.
May your lordship please, senior is engaged in another court.
Your senior is engaged in another court, but as far as this case is concerned, it appears state has not filed a return. Yes, any plan for filing returns? Yeah, Mr. Goswami, Ms. Bordeloy? Yes, Ms. Sharma? Huh? Acha. Ms. Das will file? Mr. Goswami? Yes. How much?
2 weeks.
Huh?
2 weeks.
2 weeks. Mr. N. Goswami, learned government counsel, seeks 2 weeks time to file return in the matter. Anybody else is going to file anything?
No.
Prayer is allowed, released after 2 weeks and a date to be fixed by the registry.
Item 24.
May I please your lordship, lordship in this matter instruction is awaited, lordship. We seek another 3 weeks time. Copy in our instruction.
This is for hiring charges.
Hiring charges.
Yes, lordship.
Bill,
Lordship.
pending since when?
Uh,
Why is the instructions taking so much time?
Lordship, they have also come late, lordship.
Oh, that is all right if they have come late.
Lordship,
But why are you not paying?
lordship,
Huh?
that we have to take instruction.
That is the only instruction that you need to take.
Lordship.
Because you are not paying, they have to come and finally knock the doors of the court. Huh?
We will obtain those.
How much time?
Lordship.
Monday.
3 weeks time, lordship.
Monday.
Lordship, 2 weeks time, lordship, make it done.
2 weeks. Next Friday. You get it?
Lordship.
Heard MS.
B. Gogoi.
D. Gogoi, learned counsel for the petitioner, also heard Mr.
R. Talukdar.
R. Talukdar, learned
Appearing
counsel
respondents.
appearing for the
On
state respondent,
All the respondents.
for the respondent. You're appearing as a additional,
Junior government advocate, lordship.
as a senior,
Junior government.
junior, government counsel, learned government counsel appearing for the state respondent. Huh? Mr. So-and-so Talukdar seeks 2 weeks time to file return in the matter. Prayer is allowed, released after 2 weeks on a date to be fixed by the registry.
Public.
Pilot, it is needless to be clarified that since the issue involved in the writ petition is non-payment of the hiring charges, vehicle hiring charges bill, the return shall be positively filed by the next date of listing, failing which the matter shall be proceeded in accordance with law, including passing any adverse orders.
Public.
25.
May I please the lordship?
Yes, payment
Sir,
of
in this
insurance
case-
claim.
My lord, in this case, my lord, the petitioner.
Where is your counterpart?
Lord, is the-
Service of 2 and 3 is complete. Anybody appearing? Yes, I can see name is no. Finance is there. 2 is R. Sharma.
My lord,
Where are they? Affidavits have also not been filed.
no, my lord.
I think, see if you can get hold of Mr. Goswami. I think finance. You can just ask for someone. Finance is there, Mr. Nayak. I think affidavit is to be filed.
Lordship, not fine.
Not filed. So,
I'd like to have some instructions.
Mr. P. Nayak, learned, Standing Counsel Finance. You're appearing as Standing Counsel or Additional Advocate General in this matter?
Finance.
Standing Counsel Finance seeks 2 weeks' time to obtain instruction in the matter. Prayer is allowed. Prayer is not opposed. Relist after 2 weeks. On a date to be fixed by the registry.
The date may kindly be fixed, my
Let
lord,
them file
otherwise
it.
it
What is
it
the
won't
point
come,
of
my lord.
giving dates? You don't worry, registry will give it after 2 weeks. In case your case is not getting listed after 2 weeks.
My lord.
On a, by a reasonable date, you are at liberty to approach this court and mention.
Deeply obliged.
28.
Yes,
In this matter, my lord, yesterday an affidavit has been filed, my lord.
huh?
Yesterday,
You filed your affidavit.
yes.
It's not in the. All right. MS Yudas, learned additional senior government advocate, submits that the affidavit in opposition on behalf of the respondents,
Number 4.
on behalf of the state respondent number 4 has been filed yesterday. However, the same is not on record. Let registry verify and place the same on record. Yes, when do you want? You want to file rejoinder?
My lord.
Mr. So-and-so, learned counsel, MAI Hussain.
Yes, my lord.
MAI Hussain, submits that he has received the copy of the affidavit in opposition and accordingly seeks how much time?
2 weeks, my lord.
2 weeks' time to file rejoinder to the against the said affidavit in opposition. Prayer is allowed.
Right.
I've said now, listing.
29. In this case, if lordship comes to the prayer slot, case 10.
1 second, Mr. Nayak.
Lordship.
Page
10. One.
Yes.
First prayer is for a direction to respond number 6 to attach the land in dispute, lordship, that is one. And 2, lordship, direction may be issued to the respondent number 7 to appoint receiver. Now, so far as these 2 directions are concerned, lordship, if lordship comes to case 17, 17.
Yes.
This is the order passed by the assistant commissioner, lordship, as executive magistrate. If lordship comes to case 17 down below, lordship 1 and 2,
Yes.
that direction is already there.
On being asked, no.
Lordship,
Down below where?
yeah, page number 17, serial number 1 and 2 down.
There's no serial number in my page 17.
Annexer 2. Page 17.
Page 17, there is no annexure 2.
Annexer 2.
That is page 22. Yes.
Order,
Attachment of the land,
yes,
appointment of receiver, yes.
has already been done now.
Then it's done. What is whatever your prayer have already been done by the order of the executive magistrate.
And-
You have only annexed it.
The same petition or not, hearing also in this order, it was the same petition.
Yeah,
Lordship kindly allow some time,
sorry.
allow some time. Lordship kindly allow some time.
Allow time for what?
My senior legs in some another court.
Your senior. Who's your senior?
I Rafiq.
Huh?
I Rafiq.
But why are you not reading the brief? You are having the brief.
Yes.
Before you come to take time, you must at least have a glance of the prayer. You must be able to respond to the to the court if a query is asked, isn't it? These are the opportunities. What to do, Mr. Nayak? All of Davis pass over then. Ask him to be here.
My love, wait for some time, my love, I will not receive instruction.
MS Udas, learned additional senior government counsel, seeks 2 weeks time to file a return in the, to obtain instruction and do the needful in the matter. Prayer is, because if you take time for filing, for obtaining instruction, next date you will say, I have received the instruction, now give me time for filing return. It delays matter.
Correct.
So, you get your instructions, do the needful.
Correct. That's
Made pleasure lordship, lordship similar matter,
Yes,
Huh?
I need 2 weeks time to.
Similar order,
in the similar matter lordship.
similar matter.
Yes, lordship.
Uh-huh.
I need 2 weeks time to file our affidavit, Lordship.
Your name?
Bigogo lordship.
No,
And SR Burma.
SR Borwa, learned counsel for the respondent 1, 3 and 4, and 5.
4, 5.
है ना?
Yes, 1.
Seeks further
2 weeks,
2
Lordship.
weeks time to file return in the matter. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
Obliged.
Made pleasure, Lordship. In this case, private respondent filed their affidavit in opposition, Lordship. I need some time to file reply.
MS R. Chaudhary, learned counsel appearing for the petitioner, seeks 2 weeks time to file rejoinder against the affidavit in opposition filed on behalf of the respondent number 5. Prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry.
Lordship, there is an interim order.
Interim, if any, shall continue till the next date of list.
Lordship, I'm deeply obliged.
Contractual bills.
Lordship, we have already on behalf of the deputy commissioner, we have filed our affidavit, Lordship. So we have returned to the proposal to the PNRD department, Lordship. On 3 occasions, all these things I have brought it on record, Lordship. So once the fund is received, Lordship, then we can.
Where is PNRD? Huh? Instructions awaited. What is there to be awaited? They have already written, now you've sent the funds. Isn't it?
Yes, Lordship.
Where, which paragraph of your affidavit?
Lordship, paragraph 7, Lordship, of our affidavit, filed on behalf of respondent.
Yes. The deponent begs to state that the proposal for reimbursement of pending liabilities of the petitioner amounting to 11 lakh so and so has already been submitted to PNRD. And once the additional fund is received, the payment will be made to the petitioner accordingly. Why are you taking so much time to give it? This letter was sent on in 9 September 2022.
Then Lordship subsequent on 40/24 and 22/4/25.
Then,
Occasion, Lordship.
then which,
Annexa A, B, C. Lordship.
correct.
Yes.
4/2 and 22/4/2025. This cannot go on like this. Friday. You get your instruction on Friday. No, Friday. This can't go on like this. Heard MS?
Arjukuli on
So and so, learned counsel for the petitioner, also heard Mr. A.
SR Burma.
SR Borwa, sorry. SR Borwa, learned counsel appearing for respondent number
1, 4 and 6.
1, 4 and 6 and MS and Bora, learned counsel appearing for learned standing counsel PNRD with within bracket or say for respondent numbers 2, for respondent number 2. Mr. SR Barwa, learned counsel for the
District Commissioner.
district commissioner submits that the proposal for reimbursement of the pending liabilities of the petitioner has already been sanctioned and submitted to the, has already been submitted, not sanctioned, submitted to the PNRD department way back on 9/9/2022 and which was followed by letters dated 4/3/2024 and 22/4/2025. However, due to non-receipt of additional funds, the said payment could not be made to the petitioner. The aforesaid stand of the district commissioner is also pleaded in the affidavit in opposition filed on behalf of the respondent number 4 on 15/5/2025. MS so and so learned counsel for the PNRD seeks a short accommodation to obtain instruction in this regard. Considering that the payment has been considering that the payments are being pending since 2022, despite the district commissioner having written for submission of furnishing of additional funds, comma, the PNRD department, MS so and so shall apprise this court on the next date of listing as regards the time frame within which the payments can be, the funds as requested by the respondent number 4 can be made available in order to for payment thereof to the petitioner. Relist on Friday, such and such date. Huh? Monday. All right. Monday, I can accommodate till Monday, but not beyond Monday. Positive. Monday.
Must be so.
Public.
May I please, your
Yes,
lordship?
where are the substantial questions of law?
My lord, the substantial question of law is at page 4, my lord.
Yes.
My lord, I filed a suit for recovery of possession, my lord.
For recovery of?
Recovery of possession. My case is this: I purchased the land, and the owner of the land subsequently dispossessed me from the suit land. Then I filed a suit for declaration of my right title interest and recovery of possession. Well, the suit was actually the land was belonged to one Umesh Pal. Umesh Pal has 3 sons, Gauranga, Bhajendra, and Ravindra. Gauranga and Bhajendra sold the land. In the suit, where I got the name mutated and I am in possession of the land, the Gauranga and Bhajendra dispossessed me from the land. And they stated that the land is unpartitioned land and it cannot be sold to any person. But the trial court and the appellate court held that the land cannot be sold as the Rabindra also the one of the owner of the land. And then our point is this, my lord, the land can be sold so far the share of Bhajendra, Gauranga and Bhajendra, I can get the title over the land. Even though the land is not, Ravindra's land is, I am not entitled to get. But after partition, I am entitled to get that land. But there is a decision of the Supreme Court also to that effect. And these are my point for admitting the appeal. And moreover, my
Let
lord,
us see the question that you have proposed.
page 4, where the courts below were justified, whether the court below is justified in considering the written statement filed by the defendant number 1 and defendant number 4. They said did not stand in the witness box in supporting the case. They have filed a written statement, but they have not given any evidence. But the evidence given by their son. Whether the finding of the were correct in holding that the plaintiff could not acquire the valid title on the strength of the sale deed exhibit 2, inasmuch as the co-owner did not file any counterclaim for cancellation of the sale deed. There was no counterclaim for cancellation of the sale deed. Therefore, my right over the land is there. My sale deed is not cancelled. Therefore,
One
I
second,
am
let me understand whether the findings of the court below were correct in holding that plaintiff could not acquire a valid title on the strength of the sale deed in as much as the other co-owners did not file any counterclaim for cancellation. Whether the courts below misinterpreted section 40. This is a concurrent finding.
yes.
You are challenging the concurrent
Yes.
finding. And section 41 of the yes, where is the judgment?
Judgment is at page number 42.
40?
42, that is the appellate court judgment.
Yes.
Your Lordship, kindly turn to page 54, issue number 2.
Yes.
Issue number 2 is whether the plaintiff acquired valid title over the suit land on the strength of sale deed number so and so. And the finding of the lower appellate court that the plaintiff has not acquired the valid title. And the landed court also upheld the finding of the Munship. And the learned appellate court relied on a decision which is at page 54. Say Gulamsan versus Nandalal Shaw. Held that the co-owners alone was not competent to transfer the entire property without getting his share determined and demarcated so as to bind the other co-owners.
What is wrong in this finding?
My lord, the wrong is this, my lord, so far my vendors, I am entitled to get my vendors right over the land.
5 vendors.
Yes. So far the appellant purchased the land from the two sons of the Umesh Pal.
You are the original plaintiff.
I am the original plaintiff.
And you have claimed that you have purchased this land from
Two of the son of original owner.
2 sons of the original
Owner.
Pattadar. And then what was your prayer in the plain?
For declaration of right title, interest and recovery of possession.
over that, over the possession.
Yes.
So on the basis of that sale deed.
Sale,
And the trial court have said that is not valid
not valid,
because the others have not signed.
not signed.
Have I understood it correctly or not?
Yes.
But that is correct. If the property is undivided and it's a joint property, then how can this sale be valid when the others have not signed?
So for the land of my vendor, the two sons of the municipal, that portion I will get. Entire sale deed cannot go because in
No, but is the land, but that sale deed doesn't talk about only his land.
yes, my lord.
You see, right now, this is a substantial question of law that has to be, unless there is a substantial question of law, this court cannot go in. This court is now not the court of facts, right? The court of final facts have already seen the facts and have concurred with the findings of the trial court.
No, concurrent finding is a different thing. Concurrent finding may also
Yes,
wrong.
only this court can now for you, so as to maintain the second appeal, there has to be a substantial question of law, right?
Substantial
Now,
question of law.
Question of law here, because it is apparent that the other co-pattadars have not signed, then how can that sale date for that particular entire land can be
Because
said to be
they have not,
valid?
because they have not paid for cancellation of the sale deed. My sale deed is there. And moreover,
So if it is there, then you very well, then you go and say that you only won that part. You ask for demarcation for his land.
yes,
That now because your prayer in the suit is not only for that.
my lord,
Let's see what is your prayer in the suit.
page 11, my lord. Page 11.
This 5 bigha is the entire land,
Yes, entirely.
isn't it? Now schedule A, so schedule A is the entire land.
Yes,
Here, some portion of the land is obviously going to be of that particular two persons who have signed.
yes.
But your prayer is for declaring your right over this entire land measuring 5 bighas. And the trial court has correctly held that when the other co-pattadars have not signed, how can this sale deed be valid for the entire 5 bighas?
Well, learned.
You see, Mr. Counsel, this court doesn't find any substantial question. You want to rethink and prepare, but this is what you need to convince. Because the question, there can be a question of law, but the question of law has to be of substance. It must be affecting the right, isn't it? Now you could have argued all this because your own prayer in the plain is declaration of right over the 5 bighas.
Yes.
And that 5 bigha there is not only of those 2 persons who have sold you. Admittedly, there are 3 more persons. They have not signed.
They have not signed.
Then what is the error that and anyway, I am now exercising second appellate court jurisdiction. So what question of law substantial question of law?
Section 44 Section 44 of the Transfer of Property Act.
Section 44. No, transfer of property, they can CPC, sir. I was wondering why I'm seeing order rule in Transfer of Property Act. By mistake, the CPC was given to me. You want section 44 of Transfer of
Transfer of Property Act. MLA. MLA.
Yes, 44.
Where one of the two of the co-owners of the movable property legally competent on behalf of the transfer of the share of the property and
That is a different question, his share. But
Yes.
here he has not transferred his share. You are also asking for the entire property.
his share can be,
Mr. Counsel,
yes, yes,
please understand that right now you're before the second appellate court. I could have understood if your prayer was for his share. If suppose he is not giving his share, or after he has sold his share, the other persons are obstructing you to get that particular share of his, then perhaps that would have been a different situation. But now, admittedly, what you are saying is that 5 bigha is the entire plot of land.
and property.
Then how will 44 come in? Because that sale deed appears to be a fraudulent sale deed. How can the two persons sell the entire 5 bigha without without the other 3 people giving them the power of signing?
But I am entitled to the share of my vendor.
Your land, where is the sale deed?
Sale deed was not executed. Huh?
How can you not exhibit the sale deed?
Oh, no, sale deed was.
What are you saying, Mr. Counsel?
No, no,
Your whole
sale deed
case
was
is based
executed.
on the sale deed.
Sale deed was exhibited, but it is not in my memo. Record.
Yes, I'm going to dismiss it now, or you want another date, Mr. Counsel? I'm not convinced.
Sometime a date may be given. I shall satisfy or not.
Tuesday, next Tuesday.
Next Thursday, madam.
Heard, Mr.
A.C. Sharma.
So-and-so learned counsel for the learned senior counsel.
Yeah.
Appearing assisted by Mr. So-and-so for the appellant. Prima facie, it appears there is no substantial question of law involved in this appeal. However, Mr. So-and-so seeks a short accommodation to for advancing further argument in the matter. Relist on Thursday, next Thursday. I think that's good.
Hello.
Matter.
I'm sorry, Your Lordship, I was at legs, some other court. Lordship, this matter pertains to non-payment of compensation, Your Lordship.
Yes.
There was an award in my favor. It is in page 20, page 19.
Yes.
Page 19 is the vernacular copy.
Now BTC is not there, I think.
Yes, Your Lordship.
They were there when earlier.
I may inform them.
Huh? একেলগে থাকিলে মাতিব Again, Council Ayler. Why have you informed him to
I'll
call the
inform him.
matter when the other head council is not here? You will be not present in the court when the
I-
matter is called.
I'm
Then
so-
you will walk into the courtroom and you will tell the court master, now call my matter without even sure whether the other side council
The
is
other
here or
side was
not.
here, but perhaps,
Where is he? He's not here now. Please do not
Yes, sir.
unnecessarily waste the judicial time of the court.
I'm sorry, Your Lordship. Matter may be passed over for the day, Your Lordship.
No Passover
I'll call-
holiday.
I'll call.
Let both the councils be here. Yes. Passover খিনি পিছত মাতিব এতিয়া লিষ্টখন মাত এইটো second time হৈছে সেইকাৰণে এনেকে নকৰিব লাষ্টত মাতিম
কিবা instruction আছে? কিবা instruction আছে নেকি?
This is a contempt case. Yes. Why no affidavit filed? It is 2016 matter.
Last two occasions, petitioner did not appear.
Huh?
No.
The petitioner not appear is a different kind of thing.
And
You see, Mr. Counsel, please understand that this is a contempt matter. It's not a writ petition. Petitioner's appearance or non-appearance is now inconsequential. Petitioner's role is over. The moment the petitioner files the contempt petition and draws the notice of the court that there has been a non-compliance of the order passed by this court. Thereafter, it is for you to satisfy the court that thereafter the matter is strictly between the contemptor and the court. Petitioner has no role. And this matter is pending from 2016.
before that, on 39/24, petitioner was supposed to take instruction. According to us, the payment has been made.
No.
There was,
He's saying no.
there was an,
Have you filed your affidavit? See, that is the difficulty. That is the problem. You will not file your affidavit. You will stand before the contempt court and you make a submission that it is complied. That is not the way to do contempt matters. These matters cannot be handled in such a casual fashion. Absolutely not. The minimum courtesy in a contempt petition that is expected from the contemners is that an affidavit is filed before the court. If you have complied, you put it in your affidavit. There are instances when despite compliance also there could be a contempt because you have not done it within the time period. There has to be an unconditional apology. Why are these things being so casually done nowadays?
if I'm appearing on the number 3, but he is no more the chief engineer, he have retired also.
You will have a lot of reasons for not filing affidavits. But who is the other contemptor? Who is respondent number 1?
He is also not the chief
He
engineer.
was earlier, my lord.
Obviously, it's a 16 matter. Now they will all be changed. But Mr. Counsel, please tell the person for whose the contemptor that you are representing that he may not be there right now, but that will not absolve him
Yes.
from his responsibility for complying with the court's order till he was in that particular office. Making it very clear to you.
Only also.
I'm making it very clear to you. A change of incumbent doesn't absolve him.
Lordship, the
He shall continue being liable. The only reason why the new incumbent is brought on record is for an effective implementation. That is the only reason.
the petitioner have also given a power of attorney to another person and the payment was made to him.
Where are those affidavits?
While being it on the,
Where are those affidavits?
that instruction was to be taken. Lordship, while being it-
I don't approve such kind of casualness in contempt petitions.
while being that on.
You have to file your affidavit. Am I clear?
Lordship,
How much time?
but the chief engineer have changed lordship, so.
But that particular, you see, you are not appearing for the post. You're appearing for the person. The person has expired.
Not expired.
Then the person is still there. You have the instructions in your hand. File it
That was given by the department.
through him. You are not the department counsel here. You are for that particular person. Is there any difficulty in understanding the language the court is speaking? Please be mindful that you are before the contempt court. This is not a normal writ petition.
I'll bring it on.
And in the meantime, you find out if if there are new incumbents, then you'll have to bring them on record by filing necessary impeding.
Right.
Heard, Mr.
Yes, sir.
So and so, learned counsel for the petitioner also heard Mr.
She Sharma.
C. Sharma, learned counsel appearing for the respondent numbers 1 and 2.
Only,
For respond, earlier you have said 1,
no,
2. In the last order, it is mentioned as for 1. Anyway, for 2. Mr. Sharma submits that the order of the court has been complied. However, and 6, a short, stop. It appears that the petitioner is disputing the said compliance. In absence of any affidavit on behalf of the contemners, it is difficult to proceed with the contempt petition. It is difficult to ascertain whether there has been compliance or not. That being so, Mr. So-and-so is directed, Mr. So-and, that being so, Mr. So-and-so, as such, request seeks 1 week time to file, to place the instructions by way of an affidavit. Prayer is allowed, relist after 1 week on a date to be fixed by the registry. In the meantime, the petitioner is at liberty to do the needful for impeding the
Present. Present.
for impeding the new incumbents to the post of the chief engineer,
water resource department.
water resources department, the post of
Right.
a date is 1 week or episode. Immediately file it.
Right.
And Mr. Borua, please give him the information. Who is the new person who's holding that post? Yes.
Rightfully so, Lordship.
Mohanto.
Yeah, I'm paying for respond number 4, my lord.
Hmm.
If you can see the last column, my lord. It's
Huh?
Last order with 6,325.
20?
It is 6,325.
Yes.
What asks me to take instruction whether the requisition is disposed of or not, my lord, by the department.
Yes.
Let not test out the file, my lord, department. Yes, okay. To let this
Yes, Mohanto.
time, my lord, 2 weeks time, my lord. So all pending, so
File your affidavit,
my lord.
whatever it is.
The next day, if they could not file.
MSPR Mohanto, learned standing counsel for the, but you are appearing here as a standing counsel or for the, because you're not here for the department.
They made, for number 4, my lord,
In person or,
principal secretary, my lord, revenue and DM department. Here I am appearing for DM, revenue and DM department, my lord. What happened, my lord, they have not take steps, my lord, to respond number 4, my lord. Court asked me to appear, my lord.
Okay.
So,
All right. Learned standing counsel for the revenue department seeks further 2 weeks time to place the instructions as called earlier by this court by order dated 26/3/2025. Prayer is allowed. Relist after
after 2 weeks.
after 2 weeks they did your on such and such date. You file an affidavit.
Obliged.
May I please, your lordship, my lord? Last order, my lord, I have to take steps upon respondent number 3, my lord, who has died, my lord. Earlier respondent number is already appeared, learned counsel today is not present, my lord. My lord, I have received the voter list of the legal heirs of respondent number 3, my lord. I need, my lord, 2 weeks time, my lord.
What about fresh steps for service of notice upon R25 and 26?
That was taken, my lord, that was.
But the office note says it was not been received by the section.
My lord, respondent number 3 has died. Respondent number,
No, I'm talking about
lord.
respondent numbers 2, 5 and
my
6.
lord. But respondent number, my lord, that was taken on 6/6/2022, my lord.
The office note says you have not given anything.
Yes, my lord, I have seen, my lord.
Then yes, you take fresh steps, or if you have
My lord,
taken
I will take fresh steps, my lord.
office note dated 22/5/2025 indicates that no fresh steps for service of notice upon respondent numbers 2, 5, Roman 5 and 2, Roman 6 has been received. Mr. So and so, learned counsel appearing for the petitioner, appellant, na?
Appellant, my lord.
Applicant seeks to submit, no, assures that fresh steps in respect of the aforesaid respondent numbers 2, 5 and 2, 6 shall be taken within a period of 3 days from today. In view of the aforesaid assurance, relist after 2 weeks and a date to be fixed by the registrar.
Highly obliged.
Please, your worship.
Mr. Counsel, I think they need your name. Just give your name. Yes.
May please, your worship. Lordship, may kindly see the office note of the main RSA. May kindly see the office note first order of the RSA 161/2022.
Yes.
Now, Lordship, I 3924/2024 has been listed today. 3924/2024 has been listed. So in the cause list today has been listed today. This 3924, Lordship, is condonation of delay in setting aside amendment, which is very much reflected in the order, office note order, Lordship. 3925 was the substitution petition.
That was
That was
allowed.
already be allowed, but the condonation is alive. So this is not required to be kept alive, Lordship. My humble petition is there, Lordship. Prayer is that as the substitution petition has been already allowed, so the condonation of delay petition in connection with that 3925 should not be kept alive. It has become, Lordship, there's no use of.
No, where is the order of substitution?
3925 order, Lordship, that 3925 has been attached with the main file.
39. Kintu, huh? Huh? But this was this substitution. There was a delay.
There was a delay.
But that delay was not condoned.
Not condoned, but the substitution has been allowed.
No, that is your fault, no, Mr. Purva.
No, I rightly indicated the court, Lordship, but
no, if you have indicated the court, then the court would have definitely taken up the.
no, Lordship, my friend is also there, but I have indicated the court, but I surprised to see in the order that only the.
No, some condemnation application confirmed. There was 2043 days.
Yes. Now again, Lordship, there are other two I, Lordship, 6, 9.
No, Mr. Borwa, I'm relisting this on Friday.
Lordship.
It will relist for your Friday. It will
And Lordship, in the matter, also, what has
You
happened?
see, because it would be, you cannot just close the condonation.
No, sir, because yes,
And because this substitution has been allowed, perhaps it doesn't mean that that is automatically becoming.
Yes. But if the condonation
Because
has to be
unless
disposed
the
of.
condonation is done, the substitution.
Otherwise, Lordship, in the order that has been allowed, it has been stated that there is no objection, specific objection for the other side. The reasons is that's why the
condonation.
Yeah. That's why the condonation. Lordship, may kindly see the order.
So if in the order it has said that the delay has been condoned, then
I think that part is mentioned in the order. 3925.
3925.
It's a long order. Lordship.
Otherwise. Okay. 3925.
In 3925,
3925 is a small order. That is here it is issuing notice.
the before that,
No.
Lordship, there is no objection from the other side in regard to the
This is preferred by applicant substituting the legales are required to be impleted in the connected so and so and as a be allowed. Mr. Mondal, he has no objection in the event of allowing this application.
Yes.
That is allowing this application, substitution application. Now, how can Mr. Mondal object consent or no consent is material when there is a statutory delay? If there is a delay, then first that delay has to be condoned, no? Without condoning the delay, how can the substitution application be
that's
disposed of? There is a technical, something has gone wrong here. You both are, because it was, the onus was on you both to inform the court also. I don't find any order also of, in the condonation.
yes, yes, yes. There's no the condemnation. There's no such order.
That date,
Yes, yes.
of that date.
Of that, they're disposing the condemnation.
There is nothing.
There's no.
In the condonation, the last order is 24/3/2025, where notice was done on list after 4 weeks, and this order is of 24, same order,
Same order,
day,
same
day.
same date.
I think something, maybe this matter needs to be listed before the same court. Something seems to be, maybe something has happened. Now, I don't know what has happened. So something perhaps.
Some technical problem.
Perhaps there is a technical problem here. Item, need your hardwork number kita. I'm simply right now saying relist private. Ito, ponot pala po, ha? Puti do bole po. Yes.
Masuk.
May I please, Your Honor? This is the contempt for non-payment of the contextual bill. Here, kindly see the plus order dated 24/09/2024.
It's the old matter. It's a contempt again, no affidavits, Mr. Nayak.
Lordship, in this case, Lordship, direction was issued for preparation of a consolidated list and pay chronologically. That list has already been prepared. That submission was also there. His position is at serial number 30, Lordship. And in the last financial year, we have paid up to 29, Lordship. So we are going to release whatever his dues are, Lordship, within this financial year, and it will start from the, probably from the start.
But you see, Mr. Nayak, this court is not an executing court,
Lordship.
isn't it?
Yes.
It's a contempt matter. I'm not sure if we're here. I have just in another contempt case. No, I do not understand why affidavits are not filed in contempt. You see, when a show cause notice is issued to the contemptor, what does the format say?
I need to file an affidavit.
Correct.
Definitely.
But why this practice has now been developed in this high court, where in all mostly in most of the contempt cases, affidavits are not forthcoming, but submissions are coming that we have done it, we have complied, or we are releasing and all that. But that is not right.
Yes, Lordship.
That is absolutely not right.
Yes, Lordship.
The orders of the court is there until and unless it is set aside or stayed, it has to be given due respect,
Yes, Lordship. Definitely.
isn't it?
Lordship, within next 2 weeks, Lordship, I am going to file my.
You file it, you explain it,
Lordship.
and you must sensitize this issue because you are the advocate, you're the additional advocate general of the state also now.
Definitely, I will inform all my.
You
colleagues.
please sensitize this because it is not looking good. These
Lord.
contempt matters, this court is noticing, is being handled very casually. It is
Lordship.
not right.
Lordship's observation will be conveyed to every document.
It is not right. You have to first and foremost, you file your affidavit.
Lord.
Once you file your affidavit, then you explain if you are really, if something is done, isn't it?
Lord.
In fact, my lord, on 24/9/2024, my lord, they have submitted the instruction where they are saying that my name is at the serial number 7.
Yes, I have seen
Yes,
that,
my lord.
but now
Now they have changed that my
You
name
see,
is.
Mr. Counsel, unless the
Yes.
affidavits come, this is
Yes, my lord.
difficult
Let
for the
me be
court to
clarified, my
proceed.
lord.
Therefore,
Yes.
let the affidavit come first.
Let me.
Mr. P. Nayak, learned counsel appearing for the contempt, all contemners,
1 and 2.
for the contender number 1 and 2, seeks 2 weeks' time
Yes.
to file to file the return in the matter. Prayer is allowed. It is needless to be clarified since the matter is the contempt matter has been pending since 2022, the return shall be positively filed by the next date of listing, tailing which, if required, personal appearance of the contemners shall be issued. I'm making it clear so that the affidavit comes.
Definitely.
That may be fixed, my lord. Any date. Did you update it? 18 June, my lord. Obliged.
Yes, 772 days delay. Mr. Roy,
Due to that period was
delay for filing the second appeal.
second,
That period, which period?
that COVID period, Lord.
COVID has gone.
No, the delay that
Huh? You filed the IA when? In 22.
22.
Oh, this IA is pending since 2022.
Yes, Lord.
The ground of delay is COVID.
COVID and other ground, Lordship, at that time my chamber was on a renovation, Lordship. So file could not be.
Yes.
Yes.
We have filed our objection.
Serious objection.
That's serious.
Where are the grounds of condemnation in your
Condonation, Lordship. I have also filed an, as per the direction of this honorable court, Lordship, I have filed an additional affidavit also.
The first ground
Against which
sufficient.
Lordship, no affidavit in opposition has been filed.
Grounds are not explained sufficiently because
On
the
a
chamber
petition code.
15 cannot be the basis for controlling the delay.
No, that was due to leakage or negligence.
In the additional affidavit, what has been stated? Where is the additional affidavit?
Additional affidavit, Lordship, is dated 1/5/24.
Nine ki hai? Not there. Yes. Paragraph.
Lordship. It starts from para 5, page 9. Continuous page.
the additional grounds, the additional affidavit, they have clearly mentioned.
They have taken a plea that due to COVID outbreak, the limitation period should be waived off. But the Supreme Court judgment is very much clear to this effect. Had the period of limitation been expired within the pandemic period, then there was a question of extension. So this is the judgment of Supreme Court. And
So
therefore, the
that
total-
apart here, it says,
No, fault was
there
on
was
my
some
part, Lord.
damage in the office during the renovation time. Paragraph 5.
Lordship, it was due to my fault. Files were due to renovation, files were kept in a godown, Lordship. And for a long period, it was could not be traced out. Then when the files were serially put in the rack, Lordship, then I got.
This
So
is
it was my.
ultimately, it's a
Yeah.
condonation application.
but,
What is
then
to
also I
be,
leave it to your lordship.
what
but,
is to be seen is whether the grounds are bona fide sufficient or not, correct? No,
So far as renovation is concerned, well, it started in the year 2018.
it is.
2018. The judgment was passed in the year 2017.
What about the explanation before that?
Before that, there is no explanation.
When is the judgment?
Judgment was passed on 14/9/2017.
14/9/17.
2017. 17.
17.
Yes.
And the time expires when?
Thereafter 90 days.
So when? Just do the calculation.
December 2017.
12/17 expires.
Yes.
Now,
I have explained in paragraph 2.
now they filed it when?
They filed it in the year 2022.
2022 filed. So chamber shifting, the renovation work was
2018, as per their statement,
It was
February
started
2018.
from 18, Lordship.
18.
It is a 3,000 square feet chamber, Lord.
18. Which was finished by December 19. Then COVID came when?
2020.
15/3/20
Yes.
to 28/2/22. Mr. Roy, where is the explanation prior to the renovation work? Because your renovation work of your chamber started after the expiry of the limitations.
Lordship, I was stated, Lordship, Lordship, may please to take up my condonation petition, page 3.
Yes.
Lordship, para 2, that the appellant has applied for the certified copies of the judgment and decree dated so and so of TN number itna on 69/27, and the requisites were notified on 3/11/17, and the requisites were supplied on itna, and the copies were delivered to the appellant on 8/11/17, Lordship. So almost the last part of the 17, Lord. So thereafter, Lordship, from I have explained, Lordship, para 2, 3, 4.
The file ultimately was recovered on 28/12/2020, which is part of the exclusion time of the Supreme. I was just going through the timelines.
But as per the Supreme Court
So that I have understood. You see,
time could be excluded
no,
from
that
15
I
to 20.
that I have understood. That I have understood. But here now you can't be measuring everything with on a day-to-day explanation,
Yes,
right?
day-to-day explanation.
Now, if you overall, you have to see the explanation. Now, it appears that the file was given after collecting. However, at that time, there was some renovation work going on, for which the appellant was asked to come after 15 days. He has also given the money. So as per the appellant is concerned, he's done his duty, isn't it? He has, it was not negligent on his part.
No,
He
let
has
this- let this-
appointed the council, he has paid the fees of the council. The council said, I'll look into the papers and you come back after 15 days. However, the renovation was going on, he was again asked to come. By the time the file got misplaced, then when they checked, they were not getting it. At the end, they got the file only on 28/11/2020, by which time the COVID has already hit. Right?
Yes.
Now, for that time, they could not do it. Later, after the COVID period, they finally filed it in 22. So if you overall you see there doesn't appear any negligence on the part of the appellate. Counsel, yes. But for the fault of the counsel, why should the appellant suffer? Of course, in a given situation, for the negligence or the fault of the counsel, an appellant can also suffer. But those are different. Because an appellant, very true that he need not act like a watchdog. But at the same time, he needs to be vigilant. Here he has been asked, he's given the money. I think
But the actual delay is 1,520 days.
no, this office has calculated.
Calculation of the. but the-
Calculation is done by the office.
Yes, the applicant cannot get the benefit of the COVID period because the expiry, limitation period expired well before the outbreak of the COVID.
Let us see this.
But the.
Yes. Which paragraph?
Well, this first phase 2, considering the reduction in prevalence of COVID-19 virus and normalcy being restored, the following order was passed in the suo motu proceeding on 8/3/2021. In completing the period of limitation for any suit, appeal, application or proceeding, the period from 15/3/2020 till 14/3/2020.
Has the office excluded this period?
Well, this exclusion can only be.
I'm asking you something else.
Yes, excluded.
The registry has excluded it.
Yes.
After excluding it is 700
Yes.
something.
Yes, Lord. After
Exactly,
exclusion. The matter was heard by Honorable Justice Borua Lordship when the court was ready to condone.
Please don't drop references.
None, I had taken.
Please don't drop references of names in this court.
And in the next paragraph 8, it is clearly mentioned. Paragraph 8(2). In cases where the limitation would have expired during the period between 15/3/2020 till 2/10/2021, that period, my lord, has to be excluded. The actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 3/10/2021. Considering the Supreme Court order, my lord, it is very clear that he is not entitled to get the benefit of COVID period.
Yes, he has a point. The office couldn't have excluded this period. It is another thing that you have, that would be a part of your explanation. Ultimately, it would be for the court to accept that explanation or not? That will be the
That is-
discretion of the
that is-
court.
I am not denying.
That is different. But now computation of the time as 700 something appears not correct. They should have correctly done it. Because how can this period be excluded while counting? If this is not excluded, then how much? 1.5?
1,520 days.
Lordship is favorable. The length of delay is
Mr. Roy, I'm not on the merit right now. First of all, the office has to rectify this. Thereafter, it can be considered. I am ready to consider it even now. Because the explanation, it appears there is no fault on the part of the applicant. On that basis, I was ready, but the registry has wrongly counted. This is not correct. The registry will have to verify this.
then the registry may be directed, Lord.
Mr. heard Mr. S.P. Roy, learned counsel for the applicant, also heard Mr.
As this was.
A.
As this was.
S. Biswas, na? Learned counsel for the respondent,
Blood responded. Sole respondent.
for the sole respondent stuff. This condonation application has been filed for condoning the delay of 700. What is
772.
770 days in filing the accompanying regular second appeal. Stop. Mr. A. Biswas, learned counsel for the sole respondent, submits that the registry of this court has wrongly excluded the COVID period in computing the delay, in as much as the limitation period had expired much before the exclusion period, much before the outbreak of the COVID. In support of the aforesaid submission, he relies upon the decision of the apex court in the case of in re cognizance for extension of limitation. In miscellaneous application number 665 of 2021 in SMW within bracket C number 3 of 2020. Let registry verify and ascertain the delay, the period of limitation, period of delay, relist after and relist and place the matter before the court thereafter.
Obliged.
May I please, Your Lordship? In this matter, my lord, the government is supposed to file their response. Only respondent number 2 has filed their affidavit, my lord.
AR, yes, Dinath, Mr. Goswami. Last time, time was taken to file reply to the additional affidavit filed by the petitioner.
This is not a additional affidavit, my lord. Perhaps it was wrong submission on their part. We have not filed our additional affidavit. In the main case, they have not yet filed their response.
My lord, I am appearing on behalf of respondent.
When are you all filing?
I have already filed my affidavit.
Who has filed?
Number 2.
R2 has filed. Who else are there now to file?
We have been served the copy today. We will need more.
What about the others? Yes, Mr. Goswami. You are being very quiet. When? You are for? Mr. N. Goswami, learned counsel, learned government counsel, seeks 2 weeks time to file return in the matter. Who else wants to join him?
My lord, I am appearing
Mr.
on behalf of respondent 8.
Mr.
My lord, my client has expired. Well, representing person, it's an organization, but representing person at this. So some substitution petition is required in this.
You do the needful.
Well,
You do the
I have
needful.
informed them.
You do the needful.
Well,
You want to file something?
I've already filed Lordship for respondent.
And you,
Will you
Mr. G. Candelia Land Council appearing for respondent number 6, submit that a copy of the writ petition has been furnished today and accordingly seeks 4 weeks time to file return in the matter. Mr. So and so Learned Counsel for the respondent number
So number 8.
8 submits that that I think that is not required. You do the needful. করবো না লাগে, huh? List after 3 weeks on a date to be fixed by the registry for the and to enable the respondents to file their return in the matter.
Obliged.
Contempt, contractual bill.
May I please your lord? My lord. My lord, this is a contempt petition pending since 2 years. And on the last occasion,
Yes, Mr. P. Nayak had taken time.
Your lordship, regarding this content, your lordship, this has already been found that this work order that has been passed is fake, your lordship. Only thing we are waiting is the speaking order, your lordship.
It cannot go on like this, Miss Counsel. You ask the officer to be in court tomorrow then.
Just 1 week time, lordship, we get them.
Let the officer come and speak. Because this matter is going on since 23.
And also your lordship, present encumbrance.
That is a different thing.
Not in the.
That is a different thing. That doesn't absolve you. That doesn't absolve you. But can't go on like this.
That's the option.
Where is the order?
my lord, page 22. Inexorate.
Page?
Page 22.
20.
22.
Page?
Page 22. 22.
22. Yes.
Hello.
You were required to finish the exercise within 3 months. Of 3 months and off. Since from 13/5/2022. And if after such exercise the petitioner is found entitled as claimed herein 18,80,000 or any other amount, the same shall be released in terms of so and so within 7 days. No.
Last option, we get the speaking order, your lordship. So waiting now.
Contractual bill, admitted bill, you are not paying, you are not filing affidavits. You can't go on like this in a contempt matter. You will not even comply with the directions passed by the court. You will not even have the minimum courtesy to respond to the show cause that has been issued from by the court. You will not even show cause. You will go on taking time. Notice was issued on 23/1/2023, 8/9/2023. Time was sought. 19/12/2023. Again, time was sought. 16/8/2024. Time was sought. Now thereafter last 20 January 2025. Time sought. And now we are in end of May 2025.
I have not Friday last opportunity at all.
Friday. MS?
RM Barwa on behalf of Mr. P Nayak.
MS RM Burwa, Learned Counsel on appearing on behalf of Mr. P Nayak, seeks further time to file to receive the instructions and file affidavit. Stop. It appears that the matter is pending since this contempt petition has been pending since 2020, since the year 2023, and the directions which were required to have been completed within a specified time period has still not been complied with. The affidavit, the contemners has also not filed their affidavits despite receiving the show cause notice from this court. By way of a last chance, the contemners are given, are allowed to, by way of last chance, it is direct, the matter is posted on Friday, so and so date, to enable the contemners to file their respective affidavit in opposition in the matter, failing which they shall be personally present on the in the court on that date.
Hello.
Mention item number 15 and 16, Your Lordship, of today's list.
Yes.
Your Lordship has fixed it on Friday. Inadvertently, Lordship, I failed to mention that there is an interim in the matter.
No problem. It shall be continued till then.
Much obliged, Your Lordship.
15 and 16.
15th and 16th.
Punel Lucer.
Much obliged, Your Lordship.
Lordship, in this case, we have not taken steps on respond number 6A to 6E and 4A to 4F.
45 to 48, na? 49. You are required to take fresh steps.
Lordship, my prayer is that their names may be deleted, Lordship.
But you were required to take steps.
Yes, Lordship, but we could not find their address. They have
No,
lost-
then have you filed an affidavit to that effect?
No, Lordship.
You have arrayed them.
Yes.
Now you want, just because you can't effectuate the surveys, now you want the names to be struck off.
And Lordship, 4A and 4F has expired. Their name also may be struck off, Lordship.
It cannot be struck off like this. Where is your affidavit?
Then I will file my affidavit, Lordship.
You file an appropriate application for doing whatever is to be done. File an application for striking off their name. You have only added.
Yes.
Mr.
Chi Sharma, Lordship.
So and so seeks 2 weeks time to do the needful in terms of the steps which were required to be taken in respect of respondent number 6A to 6E. And also as regards the substitution application, which was required to have been filed in respect of respondent numbers 4A and 4F. Correct?
Yes, Lordship.
Stop it. So you do whatever is to be done. List after 2 weeks on a date to be fixed by the registry.
Obliged, Lordship.
May I please, your lordship? Here in this case, your lordship, as per the office note dated 11/3/2025, steps upon the respondent number 1A to 1D has been taken. Steps upon the respondent number 1A to 1D, office note dated 11/3/2025.
Yes. Notices have been issued to respondent numbers 1A to 1E by usual process.
Yes, my lord, but no service report has been received.
await service in respect of await service in respect of respondent numbers 1A to 1E. 1E, right?
1D.
No, I think process server's report has come. Service reports have been received. 1A, addressee not found, also not known. 1B, addressee not found, also not known. Same. You have not checked the office note.
My lord, maybe I missed.
Ah,
My lord, maybe I missed up.
yeah, check. Mr. Your name?
A Sancheti, my lord.
A Sancheti, learned counsel for the appellant seeks 2 weeks time to do the needful in terms of the office note dated 25/2025. See what is to be done.
Deeply obliged.
Maybe just non-compliance of order, your lordship, that you find page number.
Yes.
I have entered appearance on behalf of the sole respondent. Yesterday, we have filed a power, my lord. It is not on record. Lordship will kindly accommodate.
Mr. R. Barpujari, learned counsel, has entered appearance on behalf of
Sole respondent.
the sole respondent and seeks 2 weeks time to file reply in the matter. Prayer is allowed, relist after
Date-
2 weeks on a date to be fixed by the registrar.
Date may be fixed, your lord.
Contempt matter will come. Yes.
Lordship, may I pay for accommodation of 3 weeks, my lord, with all respect, 3 weeks connect, because they are doing the verification exercise. Pursuant to my lord.
Lords, lord,
3 weeks.
date may be fixed, your lordship. After
Yes.
this-
Anyone appearing in 54? None appears for the petitioner on call. Relist after 4 weeks on a date to be fixed by the registry. Yes, Mr. Teka?
My lord, steps on respondent number, container number 4 is not complete as per the office note 35. Anyway,
For R4,
R4.
you are for
Lordship for 1 and 2, lordship.
and 3. Await service in respect of R4. List after 2 weeks.
Yes, please. I can also take fresh steps. If
Then you say that. Mr. B. Deka, Mr. B. Deka, learned counsel appearing for the petitioner, submits that what do you say, submit? Seeks 2 weeks time to take fresh steps in respect of the respondent number 4. Prayer is allowed. List after. Sorry, prayer is allowed. Then you write. Yes, Mr.
Bhagavati for
M, no M, right?
M Bhagavati.
M. Bhagavati, learned counsel, and MS.
I'm appearing on behalf of Dina.
The and MS, your name. R. Gogoi on behalf of Mr. D. Nut, enters appearance on behalf of respondent number, Mr. Bhagavati, yours
1 and 2.
1 and 2, and respondent number 3 respectively. And accordingly seeks 2 weeks time to file a reply in the matter. Okay? If prayer is allowed to, it can.
Lordship may make it 3 weeks, lordship.
3 weeks.
But
Prayer
Right.
is allowed, list after 3 weeks. On a date to be picked at the registry. Yes, Mr. Khan?
Yes, my lord, in this case, my lord, the substitution application has been filed within time, my lord.
Within time.
Yes, my lord, and the appellant
Notice
number
is
1.
not issued.
No, what has happened, appellant number 1 has died during the pendency of the second appeal before the substantial question of law was framed. Then he expired on 17/2/25. We have filed it on 6/5/25, my lord. So my lord may allow the substitution application because notice is yet to be served in the second appeal, my lord.
Second appeal.
I have enclosed the death certificate of the appellant number 1 and also the Shraddha letter signifying who are the legal heirs. The appellant number 2 is already a party, the wife is.
One second, Mr. Khan. It's in the substitution application to IA to Luba. I 146.
1467.
Heard Mr. S. Khan, learned counsel for the applicant, stop. This application has been filed under Order 22, Rule 3, read with Section 151 of the CPC 1908 for substitution of the names of the legal heir and representatives of the appellant number 1. It is the specific case of the applicant that during the pendency of the second appeal, before the framing of the substantial question of law and issuance of notice, and issuance of note, before the admission of stroke framing of substantial question of law and issuance of notice thereof to the respondents, the appellant had expired. Correct?
Appellant number 1, my lord.
He further submit, it appears really question, huh? Authority, how? Okay. It further appears, where is the death certificate?
Death certificate is page 11, man.
It further appears from the death certificate, which is enclosed to the application, that the appellant expired on
17 to 25.
17 to 2025. Stop. That being so, then where is the
Shraddha letter is at page.
I've seen. It further appeared that the appellant has that the following are the legal heirs of the appellant. So to me, page number 5 of comma. Appellant 1. Why is it 2 1A? There is only one appellant.
No, there are two appellants, madam. The wife is already a party. So the applicant number 1A, 1B, 1C, and 1D. They,
now who has died?
The husband has died.
Appellant number
1.
With an expiry to appellant number 1. Then you have to give his name. Mr. Khan, the problem is if proper assistants don't come, it is very difficult.
That is
because
true.
you were saying sole appellant. I was that is why I was that
is true.
impression. Be more specific. Now the name of the appellant is where? Dulal Burman.
Dulal Burman, yes.
I Dulal Burman. It further appears that appellant number 2, the wife of appellant number 1, that is Srimati Bipula Burman, is already a party respondent. However, it appears that the appellant is also survived by his 3 daughters and 1 son. Correct?
Yes, ma'am.
Who are as follows. Then you say A to A. Page number 5. In view of the above, apt also that being so, the right to sue. That being so, it is essential and necessary for substituting the legal heirs, the remaining legal heirs of the appellant number 1, I Dulal Burman, in place of appellant number 1. Accordingly, it is provided that Nambur Asila, so and so be substituted as appellant it will be appellant number, no?
They will be appellant number 1A, 1B, 1C,
Appellant
1D.
number 1A to 1D.
1D.
1D. Okay? In place of so and so, huh? Stop. Accordingly, the substitution application stands allowed and disposed. Let an amended cost title be furnished before the registry for doing the needful. Anything else?
No, ma'am.
It's disposed of, huh?
May I please your lordship? Lordship, this is an IA for infringement of opposite party, your lordship. Opposite party number 1 to 4.
Notice has not gone.
No, your lordship, this is the first time.
Okay. Third MS.
FN Jamal.
So and so, let counsel for the applicant, stop, issue notice, returnable 2 weeks.
2 weeks.
Huh? Steps by registered post AD, huh? Within a period of 3 days from today.
Gotcha.
List after, make it 4 weeks. List after 4 weeks on a take to be fixed by the registry. Returnable 4 weeks. First time.
May I please? Yes, sir.
First time.
My
Issue notice Corrediva condonation application.
obliged.
First time. First time.
My lord,
Notice.
obliged, my lord.
Item number 20.
Will you open a notice my condonation application?
Lordship, I have communicated. Perhaps he's at lake somewhere else. Here, Lordship, if your Lordship pleases, there's a very small issue involved, non-payment of the awarded amount. They have told me that they have instruction that there is a civil suit pending regarding that tag number.
As prayed for by the as prayed for, released when?
Next week, any date.
Another date next week on such and such date. I'm not saying he's not present because first time when he was there when you were not there.
Yes.
Second time and third time now he's not there.
Item number 29.
No, 29. Yes.
Lordship, I've got the instruction from my senior that the matter may be closed.
Huh?
I got the instruction from my senior that the matter may be closed.
Matter is?
Matter may be closed.
Matter is closed. Sorry, Mr. Goswami, I couldn't hear anything.
Matter may be closed. You got the instruction from his senior lord.
Matter may be closed. Why? Matter will be closed for what?
Yes.
Huh? Mr. Goswami, please find out. Please find out from her. She's not being able to communicate with the court.
His prayer is to attest some land in this lordship
Yes.
and appoint one receiver.
No, but how can I just close it when she's not even aware what has happened?
That last in the first half, P9 appeared. He informed that and will complete.
Lordship, I'm appearing on behalf of that.
Yes.
Lordship, kindly make sure to each.
Oh, that attachment.
Yes,
Yes. Oh, so it is.
Yes.
All right. Your name?
N. Chakravarti.
Heard MS N. Chakraborty, learned counsel for the petitioner. Also heard Mr. N. Goswami, learned government counsel for the state respondent, and MS A. Bhattakur, learned counsel appearing for T. Nayak, learned standing counsel GMC. Mr. P. Nayak, Learned Counsel for the GMC, has drawn the attention of the court to to the prayers sought for in this writ petition, which are as follows, page 10, A to A. He further submits that the two prayers, the prayers, i.e., in relation to attaching the land in dispute and appointment of a receiver, comma, the Assistant Commissioner, Executive Magistrate, Kamrup Metropolitan District, Guwahati, by order dated 6/9/2024, in the case of Kalapahar, in the case of the petitioner, in the case of Kalapahar Astha Seva Samiti versus Bimola Nagar Club, has already attached the subject land and appointed a receiver under the provisions of section 164 and 165 of the BNSS. He accordingly submits that there is nothing for he accordingly submits that the prayers having already been met with, there is nothing surviving for adjudication in this writ petition. MS so and so, Learned Counsel for the petitioner, submits that the matter can be closed in view of the aforesaid submissions. Matter can be closed. Full stop. In view of the aforesaid endorsements made by the Learned Counsels, this court is of the view that there is nothing surviving for adjudication in this writ petition. Accordingly, the writ petition stands dismissed on being stands dismissed. Disposed of.